Must be, my lord, hearing, my lord, not group 4 matter.
If it is a hearing matter of 2024, I don't have determination. I don't have determination for hearing matters, so it is motion.
My lord, then, my lord, I will come back. If it is not, my lord, also kindly give it, my lord, so that it can be dealt with, my lord.
Yes, এটা দেখুন, এটা hearing matter থাকলে এটা উপরে hearing এ আসছে এটা ঠিক।
And my lord, another matter for inclusion, my lord, as here. It's a 2022 matter.
2022 you can give. Yes.
For inclusion.
Lordship,
Yes.
I take your leave to mention a matter, Your Lordship. This is a matter where the petitioner has been removed as the supplier of steel on the basis of arbitrary categorization. And despite of the notification
Give the slip, it will appear in the motion list.
inclusion, Lordship.
Inclusion, please give the slips. Please don't mention for inclusion. Motions, please give the slips.
Inclusion for here.
Give it. 2029, 2019 or
2023.
Group 4. Group 4, yes.
Lordship, may I mention?
May I mention, Lord, with regard to Lord, item number 679 of my list, Lord. I am praying for arbitration, Lord. No matter my Lord, have twice. The actual judge has been changed. Second, my Lord, determination it has been suited. Lastly, Lord, the post for the headmaster. Legally appointed, I challenge the appointment, Lord. So, Bari was leading it twice. Your Lordship have the matter. Respondent got to file operation for 3 days. That has been filed.
Which matter?
No, item number 679. Oh my, 679. My Lord, whom I challenge the appointment, he is going to retire in the month of November. This year, kindly got for the matter.
It will be taken up. Before that, it will be taken up.
Lordship, may I mention?
Madam, it is even
Why?
I challenge them. I challenge them. I was the first candidate.
It will be taken up. Please don't press like this.
Lordship, may I mention 2 matters. One is, Lordship, item number 372. We had challenged the show cause notice that it was filed on 21st of July 2025. In the meantime, they adjudicated the matter. We wrote to them that the matter is running, but they have passed an order. We have filed a can also. That can is also appearing in the list, Lordship. The issue relates to bunching of show cause notice and 62B. Parallel proceedings, Lordships.
Okay, give it.
And Lordship, one more matter, Lordship. This is
What is the urgency, Mr.
Lordship, now in this matter, they will proceed for recovery because they have passed a demand order. Till the time it was show cause notice, Lordship, I was asking them to give time. And I had mentioned before your Lords also. But there were various matters going in the list, Lordships. I filed it on 21st of July. Now recovery will start, Lordships.
Very well. Let us see. It will be there.
It is there in as 372, Lordships.
Very well. We'll try and upgrade it.
Lordship, one more matter, Lordship. This is regarding serial 439. This is, Lordship, I was adjudicated for a dues of pre-CIRP periods. Now, your Lordship have decided this matters and all over division bench also. This matter can be decided only on this ground, Lordship. I have attached your Lordship order also.
Your Lordship, may I be permitted to mention item number 442 of the monthly list, Your Lordship? Your Lordship, it is a refund matter. My refund rejection order was passed after the time limit to pass the order. Your Lordship, this issue has been decided by the Honorable Division Bench and the review against it is also dismissed by the Honorable Bench. Your Lordship may kindly take up this matter, Your Lordship. It's a covered issue, Your Lordship.
My lord, this is for inclusion matter. This is I have mentioned a multiple number of times. My clerk has personally gone to the department. They are saying that they have lost the file.
Lost the file.
Yes, my lord. They cannot trace the file which has come from court number 5.
দেখুন দিদি ওটা নিয়ে নিন ডাকবেন।
My lord, it can be included. It can be
Yes.
In the matter, Lordship. In this matter, Lordship, I'm the respondent, Union of India, Lordship. I'm just only praying, Lordship, I kindly allow me to file affidavit in opposition, Lordship. Custom is
That
already
will be taken up. Affidavit in opposition.
2023 matter, Lordship.
2023 matter. What? It's not in the list.
No, Lordship, I'm just praying, Lordship, just kindly give me
You prepare the affidavit in opposition. Serve
Yes.
upon them.
Lordship, I'm served already.
Very well. Then there's no problem in that. Yes. You serve it. It will be taken up. Your affidavit in opposition will be taken on record.
This matter is for inclusion and upgradation, Your Lordship.
Upgradation by. Please wait.
We have already received 2 recovery notices. We have replied to the recovery notice stating that the matter is pending, but they have again.
দেখি রিকভারি যদি থাকে you have mentioned your
I
plan.
mentioned as well as attachment.
এটা বন্ধ করে দিন। এটা বন্ধ করিয়ে।
My lord,
Your Lordship, I have already
Your Lordship, I have already given the motion for the inclusion. The reason is that why I am the mention that
You have given it, it will be included, don't mention.
the reason is that the matter is 2021 and last time the order was given in 2023. Thereafter, matter is not came up on the list.
It will come up in the list. You have given your inclusion slip, it will come up in. Sir, you want to argue with the fact? Yes. No, but it's a group 9 matter, I believe. Group 9 matter is running in the list as what? It's especially assigned matter. Hearing matter. Very well. If it is running in the list, it will be taken up. I'll take up hearing matters on some day. No upgradation for hearing matters now.
Pilot, may I pardon?
Sir, I have said no means no. Repetition will not change it. No upgradation for hearing matters as of now.
Lordship, may I permit to?
Which year? 23, I don't have determination. No. Up to 2022. Yes.
My lord,
For inclusion, my lord.
Please give, I said inclusion, please give. Why are you mentioning for inclusion? Please
my
give.
lord, may I be permitted to mention 4 matters for which pertain to COD matters, Your Lordship. Your Lordship, I need to mention those matters wherein the on the grounds of limitation. Your
Yes,
Lordship, these
yes.
4 matters.
Limitation, you
Lordship,
please write
may
a heading limitation.
All right, Your Lordship, I'll write out. And
So
Your
that-
Lordship, may I be permitted to mention some matters for extension of interim order, Your Lordship. Your Lordship, in one of the matters, the difficulty is the interim order is expiring on 9th of January, Your Lordship, and the others on 31st of January.
9 January gulo aage diye.
Your Lordship,
My lord-
permit to mention my bank account already stopped and my item number 115. We already mentioned and 26 November.
115. Please give the mentioning slip. Write the
Lord,
grounds
my-
of urgency.
My interim order is expiring on tomorrow. my lord.
Give the slip.
I have given the slip.
That's it. Look here.
Well, do not take anything. Miss Malab, I mentioned this matter earlier, my lord. But no, my bank account has been attached, my lord,
See
for
the
upgradation, my lord.
My,
Urgent
Two
You
matters.
mention the grounds of urgency,
Yes,
it
yes,
will
I
be
have mentioned,
upgraded.
my
Urgent matter.
my lord, may I be permitted to mention one extremely urgent matter? My lord was pleased to pass an order on 25th on 12th June 2025. My lord, petitioner is apprehensive to be disengaged. My lord was pleased to pass the order that petitioner can have the liberty to mention.
Which matter? What is the matter? What is the group? Which group?
Group 2, my lord.
Group 2, I don't have determination now.
My lord, irrespective of classification and
Only till 2022.
2021, my lord. My lord,
It's a hearing matter.
yes, my lord.
Hearing matter.
My
or a
lord.
motion.
No, hearing matter.
देखिए हमारे
My lord's order is there. It
I
is.
shall see if it is a hearing matter, it will appear, otherwise it won't appear.
My lord, may I be? Oh, bless.
Give the slip if it is not in the list. And it is not required.
The petition to file or given.
You have given এটা আমাকে দিচ্ছেন কেন আপনাকে নিতে বললাম আমাকে দিতে বলি
My lord, may I be permitted to mention, my lord, two matters, my lord, for seeking leave, my lord,
Please
for
don't
settlement.
mention that. Why is it going to appear for you to file opposition? You have served the opposition. It will be taken up on record on the day when the matter is there in the list. On your mentioning, I cannot take up the petitioner's matter.
My lord, for granting of leave, my lord, for settlement. For availing the settlement of dispute, my lord, leave is praying for.
You want to withdraw it?
Withdrawing from this and opt for the settlement scheme.
It had to be mentioned in it. You bring your instructions so that I can take it on record.
One more matter, Lordship. There was a negative blocking of my credit ledger on 3rd of June 25. We responded to them and then we asked them to adjudicate, issue a show cause notice. They rejected my request of adjudication, stating that I have powers to keep your credit blocked for 1 year. I will not adjudicate. And in the written order, they have given that we will not adjudicate and we will keep it for 1 year. Now, in the meantime, if they don't adjudicate, once I file my returns, it is automatically recovered.
Give it.
May I have my lords kindly to mention two matters for upgradation, my lord. These are limitation matters, my lord. Delay all within 100 days.
ওই ডিলের সঙ্গে ওটা দিয়ে দেবেন তো একজন আরো মেনশন করেছিলেন ওই লিমিটেশন ইউ রাইট লিমিটেশন গ্রাউন্ড লিমিটেশন ইউ রাইট ইন দি মেনশনিং স্লিপ
Your Lordship, what has happened in this matter is that after the issuance of pre-show cause notice, the revenue has directly issued me a notice wherein stating that within 30 days, the amount of tax, interest and penalty will be recovered under section 7512. Your Lordship. Kindly, Your Lordship, upgrade.
Don't expect it tomorrow itself and don't come and mention that I'm mentioning it twice, I'm mentioning it thrice. It will appear whenever it is convenient for the court to upgrade it, right? We delay right limitation over there so that it can be. ওই ডিলের ম্যাটার গুলো যেগুলো হচ্ছে না লিমিটেশন একসঙ্গে রাখবেন এগুলো এক জায়গায় আমরা দিয়ে দেবো যাতে তাড়াতাড়ি হতে পারে
With your kind leave, Your Lordship, I would like to mention this matter. Your Lordship, petitioner's bank account has been seized and we are
Lord, I'm mentioning for upgradation, item number 705. This is the matter regarding to promotion in career progression.
Hearing matters, I am not going to upgrade immediately. It will be taken up when I take up hearing matters. Yes.
Lord, may I be permitted to mention one matter for upgradation, item number 670 of monthly list. Lordship, this matter pertains to appointment of teacher in government.
Hearing matter, I'll not upgrade. I have said so. How many times will I say so? Yes, call on the list.
2021 is the motion. Education second.
2021 motion, I don't have determination.
Also, this is
Only hearing matters I have determination, Mr. Mukherjee. Don't waste time. Hearing matters, I don't have determination for motions of 2021 for any other group except group 4. Yes. List call.
Lordship, I beg to appear for the petitioner. I'm praying for withdrawal of this writ petition. The instructions may be taken on record.
Yes.
Your Lordship.
For a learned senior mention.
But unfortunately, my name was not recorded
And my lord, Friday, Friday can too filed, my lord. Yes, and listing automatically. Yes. Then my lord, for can my lord, maybe fix tomorrow, my lord. Yes, yes.
নামটা দিয়ে দিন আপনার আমাদের নামগুলো দিন।
In item number 17, your lordship, last occasion was pleased to direct us to file a report in the format affidavit with regarding to the petitioner's allegation regarding the seizure of cash. Now, what they have done, my lord, they have prepared a affidavit in opposition. Last occasion, no, I have told them to give the precise what my lord has indicated in the order. So for that, my lord, give me some time. Officers will come today, my lord. The officer will come, and another give me this week time only, my lord. I am seeking. And another thing is that our appearance Tuesday. And then, my lord, another thing is that, my lord, our appearance is not recorded. I have mentioned, my lord, last occasion. Paragraph number 3, my lord, recorded the submission of the CGST authority, but our appearance not recorded.
Second round of litigation, first round adjudication order set aside, again adjudication order passed, we filed appeal. At the time of filing appeal, we categorically mentioned that sum of P-deposit is required only 19,000 plus, and we paid 1,80,000 much prior to adjudication. That was not incorporated in the adjudication order in original. So we stated that out of that 1,80,000, that 19,000 plus may be appropriated. Thereafter, my lord, appeal rejected for non-filing of pre-deposit without issuance of any notice of hearing. So that amount may be adjudicated and matter may be remanded to the appellate authority. I have annexed all this challan also.
My lord, if your lordship kindly see page number 92 of the appellate authority's order, they have considered their points. They want to submit that whatever we have deposited, that should be considered as a pre-deposit. Now, if your lordship kindly see page number 92 of the appellate authority order. May I submit, my lord? I find that the appellant has filed the instant appeal without depositing the mandatory pre-deposit of 7.5% of the service tax demanded in the impugned order dated 18/4/2024. The appellant have stated in the statement of facts attached with the appeal petition that they have already paid 1,52,046, which has not been appropriated. Hence, the unappropriated amount may be treated as pre-deposit at the rate of 7.5% of the demanded amount. Now, if your lordship kindly see, I find that the appellant have deposited an amount of 1,52,046 on 23rd September 2017, and it was not clear for what purpose the said amount were deposited by the appellant. The appellant was required to pay the pre-deposit at the time of filing of appeal, which they have not done. The amount of rupees 1,52,046 cannot be treated as the pre-deposit of the instant appeal. Therefore, the present appeal will be treated as an appeal without making pre-deposit. Now they have referred Supreme Court decision, Satyanand Jha, and it is a mandatory POD you have not paid. Now the thing is that, my lord, the order in original has been passed on, my lord, 18/4/2024. In the order, the demand was confirmed 16,18,112.
Great. Yes, my lord. That no, my lord, I have deposited 2 challan which I have annexed as pay. Yes, my lord, that somehow, my lord, without any purpose, my lord, to approve to pay the amount, that was my little understanding, my lord, the amount paid, but that amount was also not considered, not appropriated in the order in original, my lord. So if I go to the order in original, if the amount 1,80,000 unappropriated, so my amount, my money, my lord, at the time of adjudication, my lord, second round, first round, honorable court, my lord, honorable Justice Mohammed Nijamuddin, my lord, set aside, and thereafter with the copy of challan I submitted, but that challan also not recorded in the order in original that we have paid that amount. Page 42 and 43. 42 and 43, my lord, 2 challan. 42, 3. One is 1,52,000, another is 28,000, my lord.
Well, it is better they can say, my lord, on what purpose they paid, because there is no reflection.
Accepted one payment, another payment also not written. We statement of fact, we categorically mention 2 challan, my lord. Yes.
My lord, one thing is that this says now after GST, this cannot be carried forward.
No,
because there is an eligible may submit. This can be treated at best because it is the prior to, my lord, subject to correction, my lord. PC Colon says or whatever the says it is mentioned, this is the under the erstwhile regime. Now today under the GST there is no such. Now another thing is that here, my lord, as such there is no claim regarding that PC Colon says or whatever they have indicated. Here they have department has said that since there is a difference in the ST3 and 26 return, so this is the unaccounted undisclosed amount, you have to pay the central excess duty.
My lord, this is Finance Act, my lord. The order in original passed under Finance Act 1994, not under GST Act. So I paid the tax under Finance Act. That works contract services 1,41,000.
Wait a minute.
Yes,
This order in original is
page 27.
Holding you liable for what? On what grounds is it holding you liable?
Lordship, kindly come to page
On the ground
79.
of this Krishi Kalyan cess and Swachh
No, my lord.
cess?
No, my lord. Page 79. It will be crystal clear, my lord. Page 79. The card sort of the issue, my lord. If your lordship kindly see.
Page 79.
Page 79, para 2.1 and 2.2.
17 appellate order.
না না আমি adjudication order clear আছে on the basis of ITR date supplied by the হ্যাঁ তোমারই তো পেজ নাম্বার
ওটা অ্যাটাচ করা আছে বাট উপরে আছে এটা
উপরে আছে
অর্ডার ইন অরিজিনালটা হচ্ছে পেজ 37 হবে
ও আচ্ছা তাহলে দেন my lord 34
37
two types of pages
না 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 দ্যাট ওয়াজ অ্যাটাচড উইথ দ্য অ্যাপিল সেট
না আমি এইটাই রেফার করছি তো
37 টা বলা সুবিধা 37 হবে কিছু সেক
79 তো সেম আছে রে বাবা 79 টা আমি রেফার করছি না
ঠিক আছে
ভালো if your lordship kindly see page 79
page 79 is page 29
37
page 79 is corresponding with page 29
yes
oh yes
same thing wherever you refer
yes I have just gone through if your lordship kindly come to page 79 para 2.1
yes 2.1
on the my lord I'm led by Mr. Dev, my lord
yes.
on the basis of ITR data supplied by the Central Board of Indirect Taxes for the period 2016 and 17, the assessee Messrs Evergreen Construction, Bokhali Lane, Malda, such and such, have earned collected taxable income amounting to rupees 1 crore 21 lakhs 90 2,446 as per the income tax return, and 1 crore 21 lakhs 92,445 as per form 26S during the period 2016-17 as per the information furnished under the Income Tax Act 1961 for providing services, whereas they have declared the taxable value of the service amounting to rupees 45 lakhs 82,885 for the said period, with the resultant effect of suppressing the gross taxable amount to the tune of rupees 17 lakhs.
Yes, Mr. Rai, it appears that those amounts which you have deposited are for different purposes.
No, my lord, same
Yes.
purpose. Kindly have a look, page 86, my lord.
Page 86.
Page 86, because that order passed under Finance Act, my lord, 94.
Maybe. Show me page
I
86.
order portion, my lord.
Yes.
I confirm the modified service tax liability because this is second round, 26 lakh something, such and such, shall be recovered from them under section 73(2) of the Finance Act 1994. So that under Finance Act, that means service tax.
73(2) of the Finance Act was what?
Service tax, my lord, I am showing, my lord.
The demand, my lord.
The demand.
And the deposits that you have made is towards water cess and something. The
Yes,
cess.
no. That of service tax, my lord. Kindly have a look, my lord, page 42.
What? No. Your challan says that. No.
My
What?
lord, works contract services, my lord. Kindly have a look, my lord. Before the Krishi Kalyan says, the first line, my lord. Page 42.
Page
42. These are the accounts code. Lordship got page 42.
Yes.
42, my lord, that major code and description, serial number 1.
Yes.
0440410 works contract services. I am works contract dealer, my lord, at that time. So this is service tax, my lord. They must appreciate this is service tax amount. And these are the Krishi Kalyan says, such Bharat says, related with, my lord, the service tax amount. So they are demanding service tax. I paid service tax. That two challans not incorporated in this order in original, my lord. Nowhere stated in the order in original that those challan considered. So my money I deposited. On P deposit required only 19,000.
19,000.
19,000. 19,536.
26 lakhs of deposit.
And 2,61,000 মাত্র সেকেন্ড রাউন্ড ওটা ফার্স্ট রাউন্ডে ছিল ওটা 2,61,000 নাও ফাইনাল ডিমান্ড
Mr. Dey, can you take instructions on what account these amounts were deposited? Because they show it is towards payment of service tax in respect of works contract services. If it is in respect of the same year and he has paid certain amounts, then why should he be burdened again?
Very well. For further clarification, we'll take instruction.
Because according to him, it is that. So what according to you it is? Because money has been paid. That is evident from page 42 and 43. If he has paid money, then in that case, we cannot overburden him with further pre-deposit conditions.
We shall take instruction.
Because that stands satisfied.
And appellate order also mentioned one challan, another challan not mentioned. Two challan there are 1,80,000. Our P deposit required only 19,536.
Very good. The petitioner assails an order
in.
Don't mention like this.
But I understand, my lord, there's some urgency with regard to.
You should have been there, sir. Yes,
But can it
20.
accept tomorrow, my lord?
I have fixed it on a different day.
My lord, great.
Chalo. Yes.
20. 20 college? Oh, sorry. I am sorry. My lord, 20 I am for the application, my lord. State GST involved. Here, my lord, I am challenging the appellate order, penalty order under section 129 1A, my lord. What happened, my lord? At the time of carrying of goods, law says that EOA bill, tax invoice or delivery challan mandatory. In my case, there is no violation of that. I was carrying EOA bill, I was carrying tax invoice and other OMN slip and also the requisite document. They accepted in the show cause notice, but they are saying that as the supplier generated EOA bill, so I cannot get exemption at my supplier charge the tax 0.10% IGST on concessional rate. They are saying this related to circular number 41, notification number 41. So your the supplier cannot generate EOA bill. But my lord, law says that when what is the purpose of goods for
Mr. Sanyal. Yes.
purpose of recording of goods in the EOA bill not to evade tax. Law says anyone, either supplier or recipient, anyone can generate the EOA bill. Rule 132 sub 830 sub rule 2 says. So accordingly, my lord, they intercepted the vehicle. They accepted that I have all the documents, but only for notification 41, I am not entitled to that. But 41, my lord, not related with the section 68, not related with the rule 138 capital.
Show me the order.
Yes, my lord.
Which you are checking.
So entire penalty may be deleted without jurisdiction, my lord. The seizure is completely without jurisdiction. My lord, may I show, my lord, from first, my lord, e-invoice?
No, show me the order then.
Penalty order, my lord. Penalty order, my lord, page 87.
And why you are not preferring appeal?
Yes. Appeal paper.
What has the appellate authority?
Appellate authority just confirm the order of the.
Show me the appellate order first.
Yes, madam. Page 118. Starting page and operative part, my lord. 123. May I read, my lord, from?
Please wait.
118 is the first page.
Yes.
So, my lord, and their physical verification MOV 04 says there is no difference of goods. The HSN code and the actual value, all this verified. And on this issue, my lord, our division bench judgment, my learned friend appeared in the case of Ashok Sharma, entire penalty deleted. I will show your lordship that judgment. But this is the appellate order, my lord. The 41 notification is the concessional. This is separate part.
And where is the original order?
Yes, my lord. At 87, my lord, starting page. And operative part 92 last, before the last para. Page 92.
Page 92.
92 operative part, my lord.
Notification to that. What do you want?
Yes.
Now, my lord, the law says, my lord, may I refer the provision of law, my lord? Rule 132, my lord. Sorry, 138, capital A.
A.
Capital A. The person in charge conveyance shall carry the invoice or bill of supply, delivery challan, ASK, and copy of EOI bill. So I am carrying the EOI bill. They are not disputing. They are saying that the supplier cannot generate it. I am recipient, so I have to generate. And also, this is e-invoice. E-invoice means, my lord, automatically recorded in my outward supply return as per the sub rule 2, my lord. That invoice QR code embedded, so it is automatically reflected in my outward return. Now, my lord, sub rule 2 of the rule 138. Rule 138.
Yes.
Where the goods transported by the registered person as a consignor or the recipient of supply of the consignee, whether it is own convenience or hired public convenience by road, the said person shall generate EOI bill in the form such and such. So either supplier or recipient, anyone can generate the EOI bill.
Yes.
And as per provision of law, my lord, I carried that EOI bill and my lord, the challan, my lord, they are not disputing. Now, my lord, 41.
The EOI bill which you are carrying was generated by you.
No, generated by my supplier. Law says anyone can sub. And what is the purpose of, my lord? To record, not to evade the tax. That is why, my lord, the scheme of the act is that anyone can generate the EOI bill. So they generated the EOI bill. Now, my lord, they are referring the 41 notification. May I hand over the copy of the notification? Is completely different. That cannot be correlated with the search jar under section 129, 68 and rule 138 capital A2. But this.
Wait. Yes.
This notification, my lord, says certain terms condition.
Yes.
Certain terms conditions to export, my lord, on concessional rate. What are the, my lord, terms condition? I am referring subclause 6, my lord. The registered recipient shall move the goods from place to registered supplier, small a, next page, directly to port, inland container, airport, land custom station, from where the said goods are to be exported. Or I have, my lord, exported from that Jharkhand to, my lord, Bonga, Petrapol for export. It's evident from the record, my lord.
Export.
Export, for export. Concessional rate.
That's why the rate is 0.
Rate is 0.10%, madam. So
you wanted to export where?
Bangladesh. So, my lord, I fulfilled the quantity, but they cannot equate it. They cannot say that 40 notification 41 has a relation with that section 68, rule 138, rule 138 capital A, or, my lord, section 129, 1 small a. They cannot impose penalty. So completely seizure is the without jurisdiction, madam. Now, my lord, I am drawing your lordship kind attention the EOA bill and invoice, madam, and physical verification report.
So according to you, this notification, if it applies, you will be entitled to exemption. If it does not apply, you will not be entitled to exemption. But in no case, penalty can be levied. That
penalty can be levied, but if it is not applicable, it is not. I am not. I faulted for any of the terms condition. So inspecting authority, what they can do? They can report to the auditing authority or the adjudication authority for adjudication. But in no case, my lord, 129 penalty can be imposed because I have complied that those section and rules, my lord. Kindly have a look at their record, my lord. First, my lord, the tax invoice for my lord. One moment, my lord. 46, page 46.
Page 46.
46. This e-invoice, my lord. When generate, my lord, e-invoice automatically reflect in the outward supply return, GSTR 1.
Yes.
46 is the invoice. Then 47 is the EOA bill, my lord.
Yes.
Correctly recorded. Then, my lord, OMN slip 48.
Wait. 46. Show me. You just
Sorry,
you are
sorry.
running through the pages.
I am sorry. E-invoice.
Tax invoice. Page 46 is tax invoice.
Tax invoice and tax charge, my lord, by the supplier 0.10%.
Where do I get
right side, second lower part, my lord. Tax rate.
Where do I get 0.01?
My lord, the last
rate is 0.1%.
Rate, yes.
Yes.
So I complied the rate, and my suppliers sell to the directly to the my warehouse. It shows from the record. And my lord, the next is 47. And also, my lord, in the 46, I may forget, my lord, that DB machine tool Bonga Petrapol. It is also mentioned that for export. Middle portion, my lord, ship to. This is bill to Salt Lake and ship to Petrapol. I must mention, my lord. And
yes.
And next page, my lord, 47. That EOA bill generated prior to movement of goods, generated 28 May, generated by such and such, valid up to such and such. Number 2, OCL Iron Jharkhand, Despram from Jharkhand to DB machine shipped to Bonga Petrapol. So for export, it was shipped.
Yes.
Next page, my lord, the OMN slip 48.
Yes.
Next page 49, my lord, the road challan.
Yes.
And my lord, Next, my lord, kindly have a look, my lord, 59, MOV 04. Physical verification report, 59.
59.
Yes, my lord.
Yes.
My lord, in the right side, my lord, description of goods, middle portion, my lord, after physical verification. Lordship got, my lord?
Yes.
Invoice details, my lord, middle portion, invoice details, sponge iron lamps loose, HSN code 7203. Middle portion, my lord. Lordship got, my lord?
Yes.
Yeah. And description of goods such and such, HN such and such, quantity as per invoice 41620 kg, quantity as per physical verification same 41620 kg, remarks no difference. So in this point, my lord, when there is no difference, goods are same, so no penalty, there should not be any penalty. And our division bench on this point, I will show your lordship, the Ashok Sharma, similar point, penalty deleted. My learned friend also appeared on that point. And my lord, kindly have a look, my lord, then penalty order 87, starting page, my lord.
Yes.
I am referring page 88, my lord, middle portion. Middle portion, my lord.
Yes.
In the tabular form, my lord, may I read, my lord, that the vehicle loaded with 41.62 MT of sponge iron lumps, HSN code such and such. At the time of interception, the driver produced following number 8 tax invoice. Next point, my lord, the EOI bill, road challan, OMNC. So they are saying I am carrying all everything. So
Yes.
So, my lord, then, my lord, page 92, last, before last para, my lord.
Yes.
Page 92, before last para, from therefore, my lord. Therefore.
Yes, it is the same thing I have read. That.
Yes, yes. So, my lord, in my humble submission, I'm understanding, my lord.
Yes, Mr. Chakravarti, if what is written here is taken at face value, even then, the ultimate result will be that he will not be entitled to the exemption in terms of the notification 41, because
Yes.
if this interpretation is accepted, then that is going to be the result.
But there
By
cannot be any
penalty.
penalty. Can we come to page 46?
Page 46.
On the right hand side, middle portion, the transporter details.
Yes.
This was a ex-factory transportation, means the buyer is responsible. The person who is buying, not the supplier. Admitted position, the supplier has the put in the e-way bills has the admitted position. Now can you see the language, my lord? Subject to correction of my little understanding of rule 138. First is 138.1. Every registered person who causes movement. 38. Every registered person who causes movement of goods.
138.1. Yes.
Every registered person who causes movement of goods of consignment value exceeding 50,000 rupees. Roman 1, 2, 3, I'm not saying. Shall before commencement of such movement furnish information relating to the said goods as specified in part A of form A. Now, this is part A. My learned friend, what I've shown a part B. I'll come to that also. So, who causes the movement of goods here? Here, the buyer who causes the movement of the goods. My understanding of the provision, subject to correction. Who causes the movement of goods? Buyer causes the movement of the goods. I should have fortified myself with some judgments. But my reading of prima facie reading of these provisions, my lord, It is the buyer who moves the goods. It's an X factory where buyer takes all the responsibility. Now, my lord, kindly see 138.2.
Yes.
My lord, where the goods are transported by the registered person as a consignor.
Yes.
Or the recipient of supply as the consignor, whether in his own conveyance or hired on or a public conveyance by road, the said person shall generate. So, two categories, consignor or consignee. Here the consignee is doing the transport, X factory. He has to, that said person. It is not an option, my lord, subject to correction, my lord. The said person has to inform it. The said person has to put in the information. My lord, the statute has created demarcation as regard to the liability who will put in the information. First part, it says a person who causes movement of goods. Second part says but the said person, it can be both, my lord, but it has to be read in the context of part 1, subsection 1, which says who causes the movement of goods, because that person will be having the information.
Right.
Admitted position X factory. Admitted. Now, my lord, the liability, the penalty amount, my lord, I can understand, my lord, it could not have been the full. I should not say all this, but this can be reconsidered. But my lord, he cannot come up with a case that he has not violated any of the provisions. But that is what I am saying. Now he is not, because moment he has given information that he is entitled to the exemption, that is also wrong information. He will not be entitled to the exemption, so tax will go up. Well, if he is not entitled to that exemption, well, the tax will go up, obviously. The consequence of the tax will go up. And well, today, deepest respect, what interim orders he is asking for. This is not a such a agent, he has got the goods back. And we like to file an affidavit in this matter. This is an interesting point of law. But this is not a
subject to correction. Many matters, my lord. My money is lying with them since long, my lord. The petition filed, my lord, in the month of March, my lord. No, April, no, long, my lord. So, my lord, April, 1st April. So, my lord, my money is lying. I am suffering from my working capital shortage because, my lord, there another case, my lord, 159, similar case, my lord. Same date, all are same, but the vehicle number is different.
Let them file their affidavit. I'll decide it. It will appear as a motion.
But I have to also
and my lord, may I submit the judgment of our honorable division?
Well, that is on a
Fire,
different
my lord.
context.
No,
This point was not raised. Who causes the movement of goods? Well, that possibly no court has decided this issue. Who causes? Who causes the movement of
that
goods?
is
Here the responsibility as per the invoice is the person concerned who is the recipient, not the supplier.
But here, my lord, who causes, my lord? Anyone can cause, my lord, because I am
no expect
anyone can cause in specific circumstances.
And
Anyone
that is
can cause. Everybody will have power to do that. But in what circumstances will you exercise that power is given over there. That is one way to read it.
Right. I am correct. But 2 says, my lord, that law say what is the purpose of, my lord, recording transaction in the not to evade the tax. So I have recorded, and here says the consignor or consignee.
But
So
if today he is not entitled to the tax, well, there would be an enhancement of the tax.
But for
there is an evasion of tax. If I have
very well, how soon can you file it?
3 weeks, man.
3 weeks will be too high.
2 weeks, man. I'll do it. I personally
do it so that I can
yes,
hear it out.
Yes.
And lordship may fix for hearing, my lord.
Yes, I'm fixing it as motion only. I'll make it.
Yes. Very.
This writ petition lays challenge to an order 21, I am releasing this matter. You get it assigned. Likhen, this matter stands released from this list.
My Lord, I'm appealing for the petitioners. My Lord, this is a matter before the High Court. Before the Honorable High Court, I'm aggrieved with the appellate order. My Lord, if I go to page 83 in the appellate order, my Lord will see that we have provided all the relevant documents. And if I have to go to the genesis of the problem, my Lord, the genesis of the problem is that I'm new to GST. It's the month of July. And in the month of July 2017, I was not given the opportunity to file GSTR 1, 2, and 3 because the portal was not ready. There was an extension for that, which clearly emphasizes that the department was not at all ready with the formalities. So since it was the first month, my Lord, I made a mistake. I have taken excess of output tax in my GSTR 3B. Similar amount of output tax I have taken as excess input. That is a mistake that I have done. But as I was told that GSTR 2 and 3 will come in the process, which has not come. Even on 11th September, we see that there is again an extension. But again, there is an extension, my Lord, for the filing of GSTR 1, 2, and 3.
The mistake was in GSTR 1.
No, my Lord, it was in GSTR 3B. Because for July, August, what happened is, my Lord, 3B had to be filed first. 3B is the return where we show our net taxes and we also avail our ITC, my Lords. So in that particular return, the mistake that I've committed, since it was the first month,
I have still to come to terms with this 1, 2, 3, 3,
my Lords,
4B. It's very confusing.
My Lords, it was the original.
Keep on asking.
Yes, my Lords, it was the original GST framework. Section 42, 43 was implemented, and it was said that how the flow will move. In GSTR 1, suppose I have made a supply to my learned senior. In GSTR 1, I'll show such supply as my outward supply.
So concept I can understand.
Yes, my Lords.
But to match the concept with the forms,
Yes, my Lord.
It will be easier for you people because you are handling it.
Yes, my Lord. So, my Lord,
if I had been used to it on the other side, it would have been.
Yes, my Lord. So, my Lord, that is the basic premise that I have made. And in support of my mistakes, I have given the balance sheet. I have given the GST.
I indicated this so that instead of saying GSTR 3B, 4B, you say what is the purpose of the.
Yes, my Lord.
That will make things easier for me.
Yes, my Lord.
If you say 1, 2, 3, 4.
I'll do that, my Lord. My Lord. Yes, my Lord. So GSTR 1 is the statement of outward supplies where I'm supposed to give my outward supplies. If that would have been implemented, my Lord, for July 2017, then what would have happened? I would have properly given my outward supply in that particular form, where I had to show my outward supply, my supplies. And also, as per the framework, there was a form by the name of GSTR 2, which was supposed to give me all the input tax credit that I'm supposed to avail. If these two forms were there, my Lord, I would have never committed this mistake. I could not have committed this mistake, my Lord, at the first instance. But due to the non-functioning of the portal, which you can see, my Lord, there are two extensions. I was not given this facility.
Mistake you could have committed, but you could have corrected it.
Yes, my Lord. I could have corrected, but again, that the opportunity was also not given because the forms got on extended. And finally, my Lord, this GSTR 2 and GSTR 3
so why do you say it is revenue neutral?
My Lord, it's revenue neutral because I have availed excess ITC for payment of excess output tax. And how my output
these two are different incidents.
My Lord, if I'll show the balance sheet that I have, if I may take my Lord to page number 13, my Lord.
These two are not correlated. You avail ITC on inputs.
Yes, my Lord.
The inward supplies.
Yes.
You pay it on the outward supplies.
Yes, my lord. But this ITC only, my lord, this excess ITC, I have offset to make the payment of output tax only. The wrong output tax I have shown. Excess output tax I have shown. And in support of this, if I take my lord to page number 13, my lord.
Page 13.
13, my lord.
Yes.
My lord, I have given a proper working of my entire account.
Yes.
So I have a supply from April 2017 to June 2007, which is my VAT period, which is backed by my, it is 13,40,988, my lord.
This is April 17 to June 17.
Yes, my lord. And that is also supported through my VAT returns, which is there on my page 103. My lord, then for July 2017 to March 2018, my GSTR sales is 26,19,344.
Yes.
This is also backed by my GSTR 1, which is the statement of outward supplies, where I have reported all my supplies properly. That is there. The total of both of this is, my lord, 39,60,332. This is in complete injunction with my ITR, which shows 39,60,333. And my ITR is also given on page 94 of the paperwork, my lord. And this is also supported with my accounts, which is there on page 84. So this is something that I demonstrated to the proper officer, that my actual output tax liability is lower than what I have actually reported in GSTR 3B form, which is the form which I have to show for reporting for my turnover and availing my inputs. And that exact same quantum, my lords, if I may take my lord to the comparison sheet.
Page.
Yeah.
Mr. Chakravarti is on his guards.
This I don't understand.
So return it.
The only thing when
My lord, this is
whether this was produced before the authority, he has not annexed the reply also, he has filed before the adjudicating authority. But how can the court today,
yes,
with deepest respect, considers this? But this is a statement, but we do not know but whether he has filed this before the adjudicating authority or not. He chose not to appear before
No, these are extracts from the returns.
Yes, this is this from the portal.
GSTR once he did not file the statement
On time.
Well, the first thing is he did not file. The first thing he said, subject to correction, and it was extended. He said, I could not file, I could not make those mistakes. But those are the statements. Today, he has come after the appellate authority. He is showing some documents which I do not know whether it was produced before the authority or not. He has not annexed this. He has not annexed the reply also, which he has filed, which was supposed to he had filed before the adjudicating authority.
My lord,
your reply is not on record.
My lord, if I go to page number 83, the appellate authority has gone through all the documents.
Gone through the documents?
I've submitted. I mean to say, when I've
no, but your reply is not here. With the writ petition, I have not annexed your reply.
No, my lords, the reply was not furnished, my lord. This thing.
That's why.
The reply was not furnished, but in the appellate, for the appellate authority, we have furnished all the details, my lord. And that is also there in page 83. It's taken on record.
You did not file any reply to the show cause.
We had filed, but all the details were not given at the time of reply, my lord. The details were given at the time of appeal. All the details were furnished, and that is also evidence. That is also taken on record by the appellate authority. But my only grievance is that the appellate authority, in spite of seeing that it's a revenue neutral transaction, in spite of seeing all the documents.
You show me how it is revenue neutral. That is why I wanted to.
Yes, my lord.
Show me that.
My lord, if I may go to this comparison sheet,
yes.
If my lord would see that the difference between the tax liability declared in 3B and tax liability declared in 1 is 5,71,527 for CGST, and similar 5,71,527 for SGST, which is in the third column. Now, if I take my lord to page number 83.
Page 83.
Yes, my lord. I'm just reading for. In support of his explanation, the appellant has paid 1,57530 against the discrepancy at the time of filing of appeal. Hence, balance of ITC of 5,71,528 SGST and CGST each remain to be reversed under this head. So whatever excess output I have paid, the same amount of input excess is reflecting for reversal as per the report of the appellate authority. And he is also taking on fact that I have submitted. The appellant had submitted a purchase and sales statement, ITC statement, bank statement showing purchase, copy of PL. What more could I show, my lords? I've shown everything: the turnover, the 3B details, the 1 details, and we also have to take into cognizance, my lord, the fact that
No,
this
but you said you did not file GSTR. Then how is
no, my
it
lord. I
possible?
said we could not file GSTR 1 within time. It was extended, my lords. It was extended.
But that has been considered by the appellate court.
No, my lord, that is not considered. That's why I'm
No,
before the
there-
Honorable High Court.
See, it says sales figures of GSTR 3B and GSTR 1 did not match. If it was not considered, how will he reach the conclusion that it was matching or not matching?
No, my lords, he is not taking the fact that I've shown excess output tax. He's saying it will not match. We are saying it will not match because we have shown output tax. It cannot match. GST or 3B and 1, it cannot match because that is our main ground that we have shown excess output tax, because of which I will the excess ITC. And he is himself taking into cognizance the fact that whatever output tax I have shown excess, that same ITC I have to reverse. And he's also taking into cognizance all the documents submitted by me. But he is not given me the benefit of going through the documents and relying upon them. That's my only grievance, my lord.
Can you see that page 83? Yes. RTP, after the appellant had submitted purchase so and so, did not match. The RTP had no IGST sale as per books of accounts, but claimed ITC of so and so under IGST head during the period 17.
My lord, may I?
Let him conclude.
The appellant also failed to prove the sale declared in GST is correct in the absence of any certificate from the auditor. He also failed to submit B2C statement and transport of documents regarding receipt of goods under section 16(2) and 16(2), which ranges so and so. The tax charged in respect of such supply has been actually paid to the government either in cash or through utilization of input tax credit and receivable in respect of the same supply. The appellant also failed to comply with the circular number so and so. Hence, in view of the above discrepancies, the appellant's claim is rejected and is liable to reverse the above ICC along with eligible interest payment under section 20. He is saying that output has shown the same amount. So that's why he's going to, but IGST issue is not saying anything.
My lord, if I may.
This has to be on affidavit, but this is a factual dispute. But I do not know whether this statement, whether the GST 1 has to be considered, the other statements has to be considered.
My lord, I would just ask my learned senior, where is the restriction that if I don't have outward supply of IGST, I cannot avail IGST credit? Where is the restriction in the law?
Well, I am not saying he says that he has
My lord, this
did not show any transactions. But I am going by what is there in
my lord,
report.
my lord, the basic issue is that if I am not having IGST supply, interstate supply, that does not restrict me from taking interstate input tax credit. There is no restriction.
Let them file their affidavit since he is disputing on facts. It's not jurisdictional something. What is your urgency here?
My lord, they have started the recovery. They have sent the recovery notice to my bank, my lord.
10%, I am staying it. As you would have done if the appellate tribunal was functioning.
My lord, if this could be actually remanded back, we could have actually.
He is taking exception to the factual position. If it was only a question of jurisdiction or law, I could have done it.
Because my lord,
now,
because my lord's 107.12, there is a gross violation of that. When he's telling that I've given the books of accounts, I've given the 3B1, he should actually see what is the difference. Why?
He has seen that. Problem he has seen that, and according to you, he has come at a wrong conclusion on that.
Because
according to him, it is.
Because my lord, he's saying that the auditor certificate is required.
This is a factual issue which I should not, without calling for affidavits, decide. So. You are putting in 10%.
My lord, it will be a deep challenge for the. It's a small business, my lord. 40 lakhs is my annual turnover, my lord.
Then I'll not stay then. That's the problem.
My lord, if
10% of the balance tax.
My lord, it's 10 lakhs almost, and so 1 lakh will be the deposit, 10%. And this is for no reason, my lord. It's just a mistake of the portal because the portal was not ready. I had to go through this challenge, and it's purely an avenue neutral transaction, my lord. So if the stake would be given without the deposit, my lord, and if the affidavit could be filed, we are ready with.
Mr. Chakraborty, how soon you come up with an affidavit report?
This will 3 weeks, but this I will request. Other matter was the point of law, but this has to factual. This
No,
is a-
but if he has not considered, there are such certain material on record which he ought to have considered, because he will be otherwise forced to pay
But
1 more lakh.
If he had gone to the tribunal, could not have filed the appeal without 10%.
That's there.
That is what one.
But I'm here because 107.12
But
violation is.
kindly fixes it the last week of January. In the meantime, we'll come with the affidavit, with the report, man, to do better. So that's a factual one. What he says is that I'll talk to the concerned officer, and they say it's a new, if he revenue neutral ballot, we cannot fight, but I will not fight a dead battle. I'll not fight.
Yes, that's there.
It's distinctly clear.
But his problem is recovery proceeding.
Yes, my lord.
I don't think,
My lord, my total turnover is 40 lakhs. So 1 lakh is, my lord, just imagine the quantum of profit that I make.
that is the structure of a revenue. My lord,
No, we are no here because of the violation, my lord. That's the only reason.
That's a factual dispute. It's not nothing on to do with law, my lord.
Because, my lord, even he's quoted circular 183, that is also not relevant.
Right, but I'll leave. But my lord, if this becomes a precedent, my lord, then it becomes a.
Yes, you pay 10%.
My lord, can we pay at least 5%? That would be a lesser burden.
No, that will be difficult, because it's after the appellate stage. There is no jurisdictional error. Let us see.
So as we know, if I may take my lords to the circular, which is issued by the board, which says that only enforcement related activities for those cross empowerment is allowed. When I say, if I may take my
Can you take this matter on notice? Can you take this one? I need some instruction. Only thing, Manoj, I do not know, Manoj, it's one of the allegation is the central has also started proceedings of the sales.
Yes.
But he has not subject to correction, he has not added central GST authority, subject to correction. Central GST authority party.
No, party. Can we have a separate rate for that?
And both the rate has to be hard together.
Yes. My lord, but here, my lord, our main contention is that the order is completely perverse. And if I may take,
if he started with the argument that he's attached to the central and central has started a proceedings or whatever.
No. My main argument is that, my lord, administratively attached to the central. So the state authorities, they cannot do a scrutiny of returns of my accounts under section 61, which they have done. And beyond that, my lord, another important thing, argument is, my lord.
You not made the central authorities a party to this. You should, they were necessary parties then.
But my lords, here parallel proceedings is not my main concern.
No, even for your that grievance that you are supposed to be assessed by the central.
Yes, my lord.
That also they should be at least proper party they are.
Okay. So should I include it or because the next matter is of the central only.
Oh.
The next matter is of the central.
We are not parties.
Yes. So for both, should I?
The next matter, why are you aggrieved by the central? Because they have also assessed, that is why.
No, my lords, there is a different ground out there. But
then that is
my lord, that is a different cause. Yes, my lord.
Then you should add central as a party.
And okay, my lords. So should I add and then submit?
Yes, as prayed for by Mr. Dasgupta, learned advocate appearing for.
I'll have to add state as a party.
State is not a party.
As prayed for, is same থাকবে. Central GST জায়গায় state add করবে, বাকি same.
So that lordship, most of the dates are same. The appeal order and appeal order all same dates. Adjudication, show cause, 2 dates, and adjudication order 2 dates. Lordship, I am a transporter. When the GST law came, lordship, for transport agency, GTA, this service was under reverse charge. Reverse charge means, lordships, If my recipient is a body corporate or a registered entity, they will pay GST and a reverse charge, and I will show that as an RCM supply in my returns. Reverse charge mechanism supplies. Now, up to 22 July, Lordship, July 22, both options could have been exercised simultaneously. For certain supplies, I could have charged 12% in forward charge, and my customers would have paid me that amount, taken ITC. And for certain supplies, I could have shown that as RCM, and my customer would have paid under reverse charge 5%. Some availability of ITC was there in both circumstances. In my case, I showed both during 17-18 to 22-23. These are the 6 years before your lots. I received a DRC 1A for all the financial years on the same day, asking me that as per BO portal. Now this BO portal is back office portal of the department. They stated that they gave a chart. This is the liability total supply as per our records. And they charge 12% under forward charge on all supplies, wherein my 95% of the supplies were under reverse charge. And they calculated a tax amount. Because I was a transporter, I did not respond to it. They issued me a show cause within 10 days. 6th of March 23 was the pre-show cause. I was given 7 days to reply. I could not reply, Lordship. They issued me a DRC 1 on 15th of March. Lordship, the statute says minimum 30 days has to be given for my reply. They give me 15 days for all 6 years to file a reply. My authorized person went to the officer with his some books of accounts, whatever was his statement. But there was nothing on record which was given on the portal. He appeared before the officer to understand what is the case about. Because they are a transporter at the end of the day. It's not an organized sector. The proper officer, Lordship, passes all the demand order on 17th of May 23. He does not give any extra personal hearing opportunity on the portal. And while passing the demand order, he increases the liability in different heads, which is in gross violation of 75(7). If the show cause is for 100, CGST, SGST, IGST to 100, in fact, head-wise also, he cannot increase. In my case, while passing the demand order, he raises a fresh demand under IGST head. In totality, he changes the demand and he raises a fresh demand. Lordship, in the meantime, there was a bank attachment. The petitioners preferred a writ petition. The court was pleased to allow the petitioners to file a writ, to file an appeal after payment of pre-deposit, subject to deposit of costs. We deposited that cost and we preferred the appeal. Lordship, the appellate authority heard the appeal, admitted all the 6 years appeal, heard the 6 years, all 6 appeals together, and passed orders. Wherein in the orders, all orders are same. He writes, yes, there is a violation of 75(7) by the proper officer, but it's a technical issue. I will ignore that. Page 157. He writes, kindly takes 157. Lordship, 159. 159, Lordship, second bullet in the instant case. My Lordship is there. May I place that? In the instant case, therefore, the respondent should have issued another notice and formally recorded the rebuttal provided by the appellant before issuing the final demand. Notice as per legal procedure aspect is concerned. However, it is pertinent to mention here that appellant himself did not bother to show any procedural compliance in response to notices issued by the appellant. He failed to upload the reply in response to the notice of intimation in DRC 1A and also to show cause in DRC 1. The appellant had preferred to make all submissions and production of documents before the respondent in course of hearing, and the respondent have informed the appellant also in course of hearing about his findings. Did not think the procedural aspect to be worthwhile in view of the non-compliance. No doubt it's a violation of 75(7). But as the demand has been raised upon due hearing and considering the books, issuance of further notice can be considered as a technical issue. Lordship, and now this chart, Lordship, kindly takes this chart what I have given. This, Lordship, sees the show cause dates in the table. All financial year show cause issued on 15th of March. All due dates, Lordship, 31st of March, except 3 years, 3rd of April. Lordship, statute provides minimum 30 days to prefer a reply. Minimum. Lordship, because why I say 73 read with Rule 142. Rule 142 says, after issuance of show cause, I can make a payment within 30 days. There is no explicit mention to file a reply. It gives me a time to make payment of the demand as per show cause within 30 days. And then only the adjudication can happen. So, on a reading of 73, 74 read with 142, I am bound to get minimum 30 days time, if not to reply, but to make payment. He gave me 15 days time to reply and a personal hearing on the 16th day. And Lordship, the demand order spoke about the liabilities were determined basis what is the back office portal data. I was never supplied. In the show cause notice, there is no annexure. It is as per BO portal. Lordship, if there is some data, Lordship, kindly first take Lordship pre-show cause at page 44. 44 is the summary, Lordships. 46 is the pre-show cause. Page 46. Lordship, 46, Lordship, this is the detailed DRC 1A. As per data available in GST BO portal, it has appeared that you have declared your turnover of supply in 3B filed for financial year this, which was less than the actual supplies. Details are mentioned. Total supply, outward supply as per records. Now, what records? This table they have given, Lordship. What is the basis of this? In the paragraph they have written BO portal. What is that BO portal? What is the invoice level data? They have nothing given to me. Next, Lordship, they issue me show cause at page 48. 48 is a summary show cause. Detailed show cause starts at 53. Same table again extracted. Again same. No further attachment to this. And then, Lordship, the order, DRC 7 starts at 92. I have attached all the year show cause notice just to give the dates, Lordships. All are separate writ petitions actually for all 6 years. 92 is the summary order, Lordships. 96 is the detailed order. Now here he gives mention about certain notifications of reverse charge. And he says, all your supplies, I will deem it to be under forward charge 12%. Why? Has he compared with my recipients? Whether recipients has paid the checks or not? No exercise conducted unilaterally. He says, because as per the view that if I do one invoice under 12% forward charge, then all my supplies are deemed to be forward charge. I cannot take reverse charge. That was clarified by the CBIC in July 22, when they amended the form and they stated now henceforth from July 22, a transporter will have one option only for a financial year. He can either go for forward charge, where he can get his input tax credit on purchase of tires, lubricants, trucks. Otherwise, on the entire year, all his invoices, he has to pay reverse charge. Because it's an unorganized sector, most of them follow reverse charge. Because the corporates pay the tax under reverse charge and they take the credit. And I don't have to do anything because I am not taking any credit also. Neither I am paying output. So I am free from any GST compliance. That is how
liability is only to your supplier.
Lordship, it is shifted under reverse charge. Lordship, the entire case of 6 years, they have made a demand of around, Lordship, 8 crores on me, 9 crores. By treating entire turnover of mine, Lordship, I took loan to pay the pre-deposit to go to appeal because the Honorable Court, writ court, allowed me to go to appeal subject to payment of cost and pre-deposit. I sold, my business is closed down because ICC Bank attached all my trucks because my EMI faulted, because my major customer was Sham Steel, and Sham Steel informed me that if you are under litigation, we will not work with you. We wrote letters to them that you release our payments, that now this case is pending. But today also, Lordship, I don't have any business now unless I clear up this case. So, Lordship, for a fair adjudication, let the department give me the data. Let them put to me to fresh notice. I am not seeking any liberty that this period is time barred. No, Lordships, I want to participate. But subject to what data they have, I will prepare my reply and I will participate in adjudication and whatever is the liability.
Did you seek for any adjournment or anything?
No, Lordships. No, Lordships. I did not seek. Lordship, but in my appeal, I categorically took all points. Lordships, may kindly just take para 2.17, page 10 of my writ petition, Lordships. I have given a summary of the points taken in appeal, which is also in APL 1. I will show that also. Para 2.17, page 10.
Yes.
Your petitioner in its appeal application submitted that respondent has passed the impugned order without application of mine, that the relied upon document was never provided, that the department can independently verify from its customer that all its supply has been made under reverse charge, that tax on the same supply cannot be collected both from the customer and from me, that the demand has been passed in principles of violation of natural justice.
How have these points been dealt?
Lordships, may kindly take, Lordships. I go down to that, Lordships. APL 4 starts at 130.
130.
130, 132 detailed order starts, Lordship. Discussion finding starts at 155. Till 155, it is my appeal memo.
155.
155, bottom, Lordship, observation. Point number 4.
155, yes.
Lordship, observation. Before coming to the merit of the instant case, the undersigned thinks it essential to navigate through the portal for the notices and replies of the appellant in respect of the instant case of adjudication. Then, Lordship, he writes regarding that DRC 1A was issued on the common portal and show cause was made available. That I have also submitted. The DRC 1A, because I had not participated, and show cause all 6 years was given on the same day, and 15 days time was given. The accountant or the whoever was the person of the transporter visited the officer to inquire as to what is this all about, because they are averse, Lordship, some part-time accountants file their returns. Then, Lordships,
this case is made out before the appellate authority.
Lordships, in my APL 1, I will show, Lordships. Shall I take you to APL 1?
I'll read this one. Yes.
Lordship, then he discusses about the para 4.3, that the violation that we talk about. He says the respondent in his order fulfilled all the basic components. He was heard on verbal virtual mode. Now, what is verbal virtual, Lordships? Verbal virtual mode. If it can be, it has to be verbal, I have to be there. Verbal virtual can mean over telephone then. He submitted that it was on recorded authorized representative Mr. Jairam Thakur appeared on 24/23 and he was heard duly. The authorized produced the inward and he went with whatever books of accounts he had, because he was unaware of what is the nature of the proceedings. So to the best extent he sent a person. Main point, Lordship, starts at 4.6, 75.7, he discusses at 4.6 onwards. I took that point, Lordship, that there is no attachment to the show cause. He stated it is from scrutiny of return. But the BO portal data he is silent. What was that BO portal? What was not given to me in show cause? He has not spoken about that also. But Lordship, 75.7, what he writes, Lordships. How can he write? It's a technical issue, Lordships. He accepts, yes. Lordship, may kindly take 75.7 forwards. At page 173, I have extracted. The amount of tax, interest and penalty demanded in the order shall not be in excess of the amount specified in the notice, and no demand shall be He confirmed on the grounds other than the grounds specified in the notice. In the show cause lordship, there was no mention of forward charge, reverse charge, just a table that as per BO portal, this is your liability. What is the basis? In the demand order, he says, okay, reverse charge, I will consider entire of your sales as per my portal and the forward charge. I want to participate in the adjudication. A fair adjudication can happen.
Mr. Chakravarti, what do you say on this?
Manu, this litigation, this particular person has a checkered history. This is the third round of litigation. First, Manu, in 2023, thereafter in 2024, and thereafter in 2025. And I would kindly consider it's just previous litigation. That is 6247 of 2024.
Page 100. Order is attached at page 100.
Petition दिखा रहा है.
वो हमको लगा ये वाला है आपका.
Yes.
So, Manu, the first time we had approached this court, challenging the adjudication to 2.12. This is of 2025, interim number. 3 writ petition, including this. This is of 2024. So, he accepts that he had first challenged the adjudication order.
Yes, but that was not entertained because of.
He had asked to go to that. Now, now this writ petition is fine. 2.1617, he has taken these points. My adjudication orders not being considered 75.7, 75.4. All these allegations have been considered. Now the court says no, go before the appellate authority and decide on the merits. It is not on a jurisdictional issue.
No,
it is subject to correction. It was not
technical.
But my argument would be it was not an open remand. It was not an open remand. Kindly see.
It was not a remand at all.
No,
Because
it was,
court did not interfere. The court relegated him to the forum available.
2023 is first writ petition. Why delegated? Second is after he failed.
Where is the second order?
Well, second is 100. In this writ petition, page 100. Kindly see.
Yes.
This
So
was
it's open. Open.
No,
you please read page 101.
Last line. I have seen 101.
Yes. Page
102, last paragraph.
Yes, that is also point of merit. Jurisdiction, natural justice is not a point of merit. It is a point of merit.
I understand that.
So I'm only seeking a remand. I'm not burdening this court to decide anything regarding GTA applicability because unless I get the documents.
This point, I'm not with you. Next.
The next issue is, question is, 75.7 has seen.
Yes.
There are two parts to it. It's my interpretation. One is the foundation. I cannot add on reasons. Second part, that
just yes.
7 is, there are two parts to it. First part is amount of tax, interest and penalty demanded in the order shall not be in excess of the amount specified in the notice. And second is that no demand shall be confirmed on the grounds other than the grounds specified in the notice. So there are two. So I cannot add on any grounds or I cannot enhance the amount. Well, subject to correction. Now my question is, my specific point is for the specific finding of the authority concerned, the adjudicating authority has based its finding on your records.
No,
At the stage.
but the show cause notice
My show cause I
is
cannot
what
improve,
he's,
but I cannot improve on the facts. But the
he is to answer on the charge which is leveled against him in the show cause.
show division bench of Allahabad High Court considering this aspect. आपको तो पता है
नहीं हमको नहीं पता कॉपी
আমার কোথায় মার্ক করা আছে মার্ক করা kindly see paragraph 5. Submissions have been made by the landed council for the petition of the action of the respondent in raising the demand to the tune of rupees so and so, whereas the notice issued was only a sum of rupees so, is expressly contrary to the provisions of section 75(7) of that, and on the said count the order in tune deserves to be quashed and set aside. Number 13. As noticed here in this, on the said aspects pertaining to point number 4 and point number 10, no response was given. An objection was raised pertaining to the power to seek document discovery. The Assistant Commissioner, by his determination made under 73(9) of the Act, dealt with the said aspects and raised demand. Admittedly, despite specific demand raised pertaining to the documents information as noticed herein, before nothing was produced and same resulted in passing of the order. As the show cause notice was specific pertaining to the discrepancies notice and had provided opportunity to produce documents non-quantification of the demand in the show cause notice, and ultimately the raising the demand when passing the order cannot be said to be in violation of 75(7). But that's why I say 75(7) had two parts. One of the reasons, but the foundation was there, madam. I have found now he has produced document where from it is apparent. Well, notice, well, subject to correction. Well, we are into the form, but notice is like an intimation to the other party of the allegation of the facts against which you have to answer. Now you come up with the documents to show that there has been IGST transactions. It is your document. So it is a contention that he has knowledge of these facts. He has knowledge of these facts. Well, this is my submission. And that's why the authority says this cannot, it has to be touchstone and prejudice. Has to be on the basis of that. He has this adjudication proceedings of 2020. At first time he has approached 2023. He chose not to fight, and he go the authority. He goes back to the authority. The court remarks the matter. 2023.
Where is that 23 order?
Well, the order is not with me. The pleadings is. I'm getting the order 2000.
I can just, because that time, Lordship, there was some confusion with the SSC petitioner. He had engaged some counsel to challenge a particular year order, which was not brought to the notice at the time of filing when a demand order of all 6 years was passed. So he had some dispute with the counsel who was appearing. So therefore, that was dismissed, and therefore liberty was taken to file a fresh detailed proper writ petition, and then the order which I attached, I have given that. So I have attached this only, Lordship, because this dealt with all the 6 years together, and I was imposed a cost of 5 lakh, Lordship, for my delay and for my lectures at the end of the petition. 5 lakh cost was paid, Lordship. But because we thought that we, Lordship, made all efforts to go before the appellate authority and took all the points there, Lordship. I can show APL 1 also. Well, Lordship, admitting 75(7) violation and then saying it's a technical issue. How can a appellate authority say yes, it is violated, but it's a technical issue? Lordship, what technical issue can be portal issues? Lordship, countering what my learned friend has told. It was dismissed.
by this writ petitioner has challenged the impute adjudication order passed by WPSP authority, which is an applicable order under the statute. Furthermore, on perusal of the aforesaid order, I find that the same has been passed neither in the violation of the principle of natural justice, nor the same is contrary to any specific provision of law, nor any prosecutorial illegality has been committed in passing the impute order. And I find that the impute order is not an exceptional to entertain the same in spite of availing of alternative. Considering the appropriate so no violation of natural justice, no violation of provision.
See, that was one of the years. In that particular case, like see who had appeared, Lordship, when the matter came before us and we saw that there are 6 adjudication orders already passed and there was no basis of that, then we challenged all the 6 before the writ court through that common writ petition, and the court in the court had mentioned that you have paid 1 court fee. For 6 matters, you pay 5 more court fees. This was in the knowledge of the court. But Lordship, because that was a totally incomplete petition, therefore this was fine, and the court accepted that, Lordship. This argument was made. But today, Lordships,
but Mr. Chakraborty, what about the secondary petition?
Look,
This is consent does not confer jurisdiction.
No.
Court passes an order.
Court has passed this order.
It has to be, both the orders has to be considered together. Once, that's why I said it was not a limited.
So it has to be seen as to in respect of which year.
That was in 1819 as per the.
So it will govern 1819 at best.
But the same parties. Same
cannot
you will not apply.
Lordship, 1819.
Extend the order to different.
That is 1819, and this order is 1718 to 2223. It covers all 6 years.
6 different.
No. The second writ petition. It covers 6 years. It includes 1819, and the writ court was pleased to pass that order for 5 lakhs coach for all the 6 years. And all the cases, and Lordship, that is why I'll show the appeal authority admitting it. Lordship, kindly takes 129. The appellate authority admitted my writ petition on, otherwise he could have rejected that, okay, you have not come against that order, I will reject it. He admitted my writ petition at page 129. APL 2 was issued.
No, against that order, appeal will be maintainable. But against that order, the findings which are there in the
that was only relegated to appeal. There was no finding.
No, in that order, he says it is neither
violation of natural justice.
Lordship, that's a
violation of.
Lordship, that was a standard order stating.
But that.
Lordship, but Lordship, this order now covers all the 6 years.
No, but this order will also have to be read in the light of that order. This order cannot be read divorced from that. So 1920 or whatever.
This is 18.
Then 1819.
1819 will have that order. Will
then Lordship, 1819, or Lordship has to decide on merits.
No, I will not decide on merits. If I see that
because
the appellate authority has gone wrong somewhere else, it may go, or otherwise I'll have to decide.
Lordship, Lordship, same SSC 6 years, Lordship. I am ready to participate. I am not taking any plea of limitation, subject to some proper information be given to me.
May I say this? May I come back? If the authorities, my instructing authority says they're happy with the remand, and I come back with the instruction.
Come back.
Lordship, they have issued a recovery notice, my charge officer. Till that time, Lordship, whenever next.
No, doesn't have to. I am informed. They should not do it. But can you keep it on next Tuesday? We'll come with the information.
Very good.
But I do not take technical points.
Hard. Since you did not place it, I
Lord-
did not record it.
Lordship may not record Lordship. Next on the returnable debt, Lordship.
Very
I will place. Okay.
না না কিছু দিতে হবে না সেম অর্ডার হ্যাঁ ইউ আর অ্যাপিয়ারিং ইন অল দি ম্যাটার্স তাহলে 31 অফ দি ইয়ে হয়ে যায় 26 to 31 করে দিন একবার
Our
দেখি
mistake, the client suffered. That observation, madam, actually,
yes it would have been brought to the notice of the court and it would have been treated differently. Now it becomes very problematic at this stage.
Because I have to also see 23 read petition whether these points have been taken off. If taken, why not possibly whether they should read to what comes. Point
আপনি দেখি আপনি I will also. Get
26 to 31 same order.
Same.
My lord, I am appearing for the petition. Actually, I am led by Mr. Obro Mujumdar. He is on his legs before court number 759.
Not today.
I'm just starting, my lord. He said he will come.
We told he will bring the matter. Sure.
I'm starting, my lord. Let's see. My lord, in this matter, we had challenged the legality of blocking under Rule 86A, blocking of electronic credit ledger under Rule 86A. But subsequently, almost 10 months has passed, and after 2 months, this read petition will be infractious. As after 1 year, they have to unblock it. So, on the last occasion, the petitioner agreed to pay 10% of whatever
Yes, Mr.
tax has been deducted.
Difficult, I tell you why. Madam, kindly come to page 35. Page 35. Paragraph, kindly submit this own admission.
Mr. Chakraborty, although there is no provision, why should hearing not be given? Because this has civil consequences.
Yes, please. Madam can say that post hearing can be given. But here, madam, there is an admission that this amount has to be reversed. He says, and he will do it within 18 minutes. Page 35, paragraph 2. This one of the partners have written, and this.
Yes, my lord, but that was subject to unblocking of our electronic credit ledger, my lord. Unless we had admitted.
I'm not reading it, kindly see paragraph 2. 35, paragraph 2.
Yes, sir.
My lord, the petitioner had accepted the demand or
Then where is your
voluntarily.
case then? If you have accepted that, then where is the case?
My lord, the petitioner requested to unblock his electronic credit ledger and give him some time of at least 18 months, and he will avail. He had available credit in his GST at 2A, 2B, anything. He will avail those credits and he will reverse subsequently. So unless the electronic credit ledger is unblocked, the petitioner cannot avail his unclaimed ITC and he cannot reverse it. At present stage, the petitioner have to pay the whole amount, whatever the determination has been made, whatever the indication has been given. No determination has been made. For these 9-10 months has already been passed. The petitioner requested the adjudicating authority to kindly adjudicate the matter.
May I give a solution? It is better, madam, to go back to the authorities and decide the authorities within 5 days. Or 5
My lord, we are ready to participate in the adjudication proceedings. Kindly direct them to unblock our electronic credit ledger. Kindly allow us to.
Why are you not deciding it then?
That's why I said, kindly, madam, 7 months he had filed a petition. That's why possibly when it was not decided.
And how many days it has been?
10 months has already.
By 4th March, they had blocked my electronic credit ledger. Repeated
Then if I direct
representation we
them-
have.
If I direct them to initiate adjudication proceedings and conclude it within 1 week.
Well, within 130 days, what is the time period? Well, there are many, it will not. But this unblocking issue can be decided within 7 days.
We have already filed representation. They have.
Then why don't you consider and dispose of
But
that?
this pendency of the writ petition, they normally do not touch any matters. That is the difficulty. His writ petition is also pending for a long time. Because he had taken a point when the negative blocking cannot be done in view of those the legal points. So that our division
We had also filed representation before block the adjudicating authority, and in response, they are
Very
just.
well, I'll also go through it. Let me, you come back tomorrow.
Great.
I'm just making it not today. Or you want me to pass an order?
No, yes, no, but tomorrow. But another aspect for it, can you consider this? This is a partnership. The person concerned who affirms this affidavit is not a partner of the firm. But he's not a partner. He just says he's an authorized signature.
It's a constituted authority.
The communications that were made by the partners. But this affirmation, when we had started the profession, we used to specify who has affirmed, who is authorized, not a partner of the firm as per the description given. But how to rely on this? Well, this has to stop. Someone has to stop this thing.
But he said, I'm well aware of the facts and circumstances.
It's there.
It must be there, but when the partners are there and this is stationed in West Bengal, it's not something is outside the state.
Both the partners have given authorized. Both the partners have authorized.
I'll come back tomorrow. But
very well. I'll also go through it in the meantime.
But negative blocking is right. But Delhi High Court subsequently had taken a different view from our Calcutta High Court. But subject to correction, our view.
Where is that Calcutta judgment?
We have already submitted a compilation, and we have already submitted, my lord.
Compilation will not do Calcutta judgment. Yes, I have got it.
But he did it.
2022 judgment.
My lord.
Calcutta High Court, is according to me still holding the.
Boshanto Kumar Shah.
My lord.
Very well. I will consider and come back tomorrow.
Grateful.
Not today, Koran.
Navneet.
এটা দিয়ে দেবেন 33 কেন কল করছে 7 তারিখ লেখা আছে দেখে কল কর লিখে নিন নানা পিএস ফর দি পিটিশনার
অরিজিনাল অ্যাপিয়ার করছিল না
no accommodation is paid for ends of justice.
I am praying for record.
The Lordship, I am for respondent who won this matter for item number 34.
Accommodation is paid for on behalf of the petitioner.
Just not today, tomorrow.
Tomorrow, not today. Not today.
I'm grateful.
The primary respondent is Income Tax Department. The primary respondent is Income Tax. My lord, in this matter,
Led by Mr. Arjun Dutta.
you're ready?
Respondent candidate, as instructed, let me start, my lord.
No, start and finish. You can do it though.
Because my lord, I have instructed in only one matter, my lord. The rest of the matters, my lord.
No, one matter is only going on now.
Yes, this one.
What is your matter?
My lord, before this matter starts, my lord, I want to give you a brief facts of the case. What happened? It's a cooperative society they had a previous number registered as a trust. But subsequently, they changed the PAN number, applied for a change of PAN number, and it became an association of person for easier approval of 80p deductions. But after that, we informed the respective bank authorities saying that we have changed the PAN numbers and it has been done to update the PAN numbers. My lord, in the year 2017-18 for assessment year 17-18, we got a notice from the department for the old PAN number, PAN number with a trust, saying that you have made a certain amount of deposits in your bank account. We explained, we appeared before them, saying that, see, the bank PAN number has changed. All the cash deposits that you are asking for, we have explained that in our new PAN number and filed our respective returns. Well, they dropped the proceedings and started a parallel proceedings under 147 for the new PAN number. Well, I'm here as a petitioner for the old PAN. Subsequently, what they did for 16-17, 18-19, and 19-20, they issued a 148 notice for the old PAN number saying that you have made a certain amount of cash deposits in the bank account. Now, as soon as we got this in for the 2016-17 assessment year, we informed and we objected